So hopefully everybody can hear me well. My name's Anthony, and welcome to this next iteration of the Tort Law and Social Equality Project speaker series. I won't take too long on introductions, but we're very pleased today and lucky today to welcome Professor Haim Abraham from the University College London, Faculty of Laws. We're especially lucky to welcome Professor Abraham because of his most recent, he was one of the recent SJD graduates of the University of Toronto Faculty of Law, so it's a bit of a homecoming. He's written in the past on the relationship between torts and issues in public life, and including most recently a OUP published book on the relation between torts and warfare. And so today he's also picking up that theme in speaking about nuisance, its relation to privacy rights, and also issues of social justice. So Haim will speak for about 45 minutes, give or take, after which we'll open it up for Q&A.
Perfect. So first of all, thank you so much, Anthony, for inviting me over. It's really good to be here at U of T, be here again, being in this room and presenting the paper. And thank you, everybody, for joining, both in person and online. I want to do is to talk a little bit about this draft paper, and this is one of the very first times I'm presenting this, so any thoughts and comments are greatly welcome. I want to perhaps start with my general arguments, what I'm trying to do in this paper. So there are three moves that I'm making in this paper. The first is to try and demarcate what can or should be considered as a wrong when it comes to visual interferences. And in the case law in private nuisance, we can see several different approaches that all seem to bundle together about visual interferences. Some of them are about looking into other people's property through windows. Some of them are about being able to see or just even know without seeing what other people are doing inside their own property. So I refer to both of this as visual interferences, and I argue that as a matter of right, people have a right to look out of their property. They have a privilege to incidentally look into other people's property, but they don't have a right, and it would actually be wrongful if they do things that go beyond that incidental right in any kind of severe way. So for example, if you are surveilling another person, if you're tearing down their various protections, that could be considered a wrong. But also, and I think this is important to note that other area as well, there is no right to demand of other people to disappear from public view. I think that this concept, the way to think about these visual interferences has been lost in court rulings when they discuss these particular areas about visual interferences, and something else has played a role. And the way that I approach that something else, or try to analyze it, is by using some elements of queer theory. So I'm using an analysis of the discourse around it and trying to find a hierarchy of land uses that is implicit in the examples and hypotheses that judges give. And the reason why I use queer theory sensibilities and methods is because many of the key cases regarding visual interferences are actually cases where there's an element of sexuality. So there would be in Costaki a case of sex workers and the neighbors advancing a complaint against them. There would be the Laws case where it was a sex store. There'll be the Mark case where there was a nude beach next to the plaintiff's house. And there will be the Pittman case from Nova Scotia where somebody jumped nude in their backyard on their trampoline. So all of these cases are cases that seem to involve an element of sexuality. It seems to me relevant to use queer theory that tries to approach sexuality and what it can hide and the type of power interactions that can come from that. But I do want to note that even at this early stage, that because we're only dealing with 6 cases, even though they're key cases, this is an exploratory bit of research, and I want to qualify at this point the findings that I have there. which are that there is an implicit hierarchy of land uses, at the base of which is privately owned residential property for dwelling, against which every other land use is evaluated, which means that other forms of usage, for example, commercial or public uses, are at a disadvantage. But also, we can also see how uses by marginalized group could be disadvantaged as well. So that's the second element that I'm doing. And the very last move of the paper is an argument on how, even through a rights-based analysis, there could be a way of articulating how public interest can come in and play a role and impact what we should do when it comes to private nuisances, considering the fact that we can identify this structural issue, which is the bias against any other land use that is not a privately owned property for the owner's own residential use. So these are the three main claims. And perhaps I can start by explaining why I even actually decided to write this paper. And the reason is mostly spite. I've decided to write this paper because I really liked the viewing platform at the Tate Modern Museum. And all of a sudden, I didn't have access to this wonderful 360 view from that particular location in the city. And I really wanted to know, why did the court reach this decision, right? This was a 3-2 decision. And it was a really interesting case. And what we can see in that particular case is that the leading opinion that is written by Lord Leggett is really focusing on a particular type of rights-based analysis, drawing heavily on what I think, or at least we can say, drawing heavily on Ernie Weinrib's work, at least implicitly, with some explicit comments and suggestions. And the way that Lord Leggett is framing his analysis and ruling is that we need to, first of all, look at the various basic elements of private nuisance. So we need to have some kind of non-trivial interference. It needs to be serious enough. And then we also need to identify that this interference is wrongful because it's not part of the give and take between the parties, that the type of use of that land is not common and ordinary. And in that case, we might have a wrong of private nuisance. And he relegates the idea about public policy and public interest coming in to perhaps the remedial stage once that issue is decided. And it is quite interesting and quite unique, because what he says is that the plaintiffs who have brought the claim, who mostly own and live in apartments at the top floors of the fully glass building next door, they brought this claim. They don't want to use any type of curtains or shielding, and they have an issue. They have people that are using the viewing gallery next door, hundreds of thousands of people a year that can look in. Some of them actually use binoculars to really look in, or take pictures and post them on social media, or even talk with them, right? So there were conversations happening. There was taunting. And what Lord Leggett is saying is that this type of interference is non-trivial, it's substantive. It's as if the people living in the new Bankside building are living in some kind of a fishbowl. So there is a significant interference here. And then he also says that this type of interference is wrongful because it's not a common and ordinary use. It's not a common and ordinary use in that particular location. And it's not a common and ordinary use for a museum generally. A museum doesn't have to have a viewing platform. So that's the way he's framing things. He's relying on a few cases to show why private nuisance doesn't require anything moving from one property to another, to try and show why visual interferences where nothing actually crosses boundaries is absolutely within the scope of private nuisance. And I don't want to talk about that almost at all. I'm not really questioning whether that is correct or not. And some people that are here would actually want to push back on that as well and question that element as well, but I'm not touching on that. And instead, I want to focus, first of all, using this kind of rights-based analysis on what it means to commit a wrong of visual interference of the kind that Lord Leggett is talking about. So the starting point for me is that we are, and this is again following the Weinbergian way of argumentation, right? So we are physical beings in the universe. We occupy a space and we have certain senses. And we also have normative relationships in relation to one another, right? We're free and equal, which means that we can't unilaterally subordinate another person without their consent or without authority to our own arbitrary wishes. So that means that, you know, I occupy this space, Anthony's occupying this space, we can perfectly coexist next to each other, but I can't really push Anthony out of the way because I want to stand where he's standing right now. Why can I do that? Because Anthony is my normative equal, right? So he has a right to stand on that space and occupy it. And the argument then proceeds to say, well, if you have a right to stand in that space, and if you are this being that lives in a world, and in order for you to actually pursue your ends, you need to be able to have certain means to achieve. So there's an argument about how you need to have a relationship to property. So even if Anthony leaves his space, that is still his space, and I can't trespass on it without his consent. But there's also a way to view that relationship with property as an extension of the self, and I don't want to talk about that too much. And instead, I want to focus just on what does it mean to have a bit of property that you stand on, right? It's your property, so obviously, and you can occupy the space, you can build up, you can build down, but even if you just stand on it, right? There are certain things that will happen naturally because you are a natural physical being, right? You'll be able to see, you'll be able to hear, you'll be able to smell. And the point that I'm trying to promote here is that your ability to see out of your property is not something that's incidental, right? I'm not saying you can have an unlimited view of everything outside of your property, but as long as you're on your property, you have a right to look out of it. So if somebody has an adjacent property, they can build all the way up to the fence, and that's absolutely fine because that's their property and they can build up, and we accept that. But what we don't accept is that people can come in and demand that you will not look, or if by some form of magic, they'll be able to flip a switch and take away your eyesight, that will be a problem too. That'll be infringing on your right because that will be subordinating you to their will. So because we are this physical beings that occupy a space, I think it's reasonable to say that we have a right to look. That includes looking out of our property as long as there is no something in the way that is providing some kind of a barrier to our sight. So we have a right to look out, which means that we can also incidentally look in. I don't think that anybody is going to have any kind of intuitive qualms about seeing people on the street, right? We have our capabilities. We have our sight. If we see somebody on the street, if we see somebody at a park, that's absolutely fine, right? It crosses a line when we stare and maybe surveil, but as long as we have our natural capabilities, we incidentally look at them, we don't wrong them. And the same, in my view, has to be true when you talk about people living inside their properties and they have their windows wide open and there is no curtain, there is no any other way of masking them. By having their windows open, they're placing themselves in public view. So we have a privilege, not a right, right? We have a privilege of incidentally looking in. People are not allowed to tear down windows or curtains or use infrared cameras to look in and spy on us. But if the windows are unobscured and we incidentally look in, that's absolutely right. At least in my view, that what follows from having a right to look out. Now, perhaps the corollary of that, so good to see you. So the corollary of that is what happens when you are in public, right? Because you are this physical person occupying a space, everybody's free and equal. If you are walking down the street, then people can see you. If you're in this public space, people can see you. And you're allowed to be in that space, and nobody has a right to demand that you will disappear from that public view. That's the corollary and the problem that I have with some of the other cases, like the Costaki and the Laws case, where the court seems to suggest that there is a right for people to demand that other people will disappear from public view. So these are the two positions about rights and privileges regarding looking out, looking in, and being absorbable. How does that relate to these visual interference cases? Well, it appears that even though the language or the attempt is to try to articulate things through a language of rights, when it actually comes to the analysis, it moves away from actual rights. And instead, there is a focus on how the substantial interference is with the use and enjoyment or the amenity value of the property. There appears to be something in the language that suggests that the actual concern is with some kind of a loss of either the actual value or the temporary value of the property. And that is something that we know that in tort law that is very unusual, and that is not something that we tend to accept. We don't accept pure economic harm in most cases. We will not say that if somebody opened a restaurant next to mine and I lose clients, that they have wronged me. All of these cases don't seem to quite align and fit. Whereas these kind of visual interference cases seem to suggest that. They seem to be focusing on something that is not necessarily rights and obligations, but actually something like a loss of amenity that appears to be important to the judges at play. So I think that these cases have been wrongly decided, that they're not really about private nuisance in the right kind of way, and they're not really treating rights and obligations properly. But what do they do, right? So how can we try and start to analyze what they actually do? And that's where queer theory and its methodology comes in. So I'm focusing on just 6 cases that are considered to be key cases that are often cited when it comes to these types of visual interferences. So now we have Fearn, but before that we had Thompson-Schwab versus Costaki. We had Laws v. Florinplace. All of these are English cases. In Australia, we have Victoria Park Racing. In Canada, we have Pittman v. Simon. In the US, we have Mark versus State Department of Fish and Wildlife. So I do a qualitative content analysis, taking an inductive and contextual interpretive approach. And I start to look at these examples and hypotheses, looking at the various words that are being used to describe what is reasonable use of property. And I'm excluding things that appear in factual basis alone or headings and things like that. So some interesting findings in terms of usage. The term land was the most common term used. It had 44 mentions in these cases, and it was followed by house with 29 mentions, property, 16 mentions, and home, 14 mentions. And the frequent appearance of land is something that I don't think is very surprising, considering the fact that it has both a very broad legal sense and a broad colloquial sense that's being used. What is interesting is that when you compare it with more specific terms like apartment, flat, farm, or factory, those are rarely mentioned, and they tend to be confined to the factual scenarios rather than to the more abstract reasoning about what might be reasonable. And colloquially, land doesn't seem to refer to things like apartments and flats and these type of specific things necessarily. The second thing that we can see through this analysis is that courts tend to invoke notions of privately owned houses and homes by an individual who uses it for their own dwelling, or to be more exact, for his own dwelling. And you can see the terms, some of them are more specific, some of them are more general, and they're used in the same kind of context as also, so they're almost interchangeable, right? So even though they're saying something very broad, like home or land, they're actually meaning somebody's particular actual privately owned house. So we can see an example from the Fearn case, and I don't want to read too much about it, but a homeowner may be kept awake to find it impossible to concentrate as a result of noise arising from normal use of a neighboring property. And if so, their only recourse is self-protection, for example, using earplugs. And they also talk about the smells of cooking during meal times. They need to close their windows, or visual intrusion. Somebody sees their home, they need to close their curtains. We can see that kind of language going on. We can see that is the second type of analysis that we find. And the third type of finding that we can see is a mirror image of that, right? So those types of land uses that are not routinely used by privately owned residential properties are often characterized as abnormal and are more susceptible to claims in private nuisance than other ones. So we can think about Victoria Park Racing and the dissent by Rich J, that is saying that it's really unusual for somebody to erect a viewing platform on their property and then add all sorts of mechanical appliances, i.e. the microphone and landline to the studio. This was before telephones were widely used. So connecting a telephone line, calling in to a radio station and reporting about the races that appear to be very abnormal, very strange, and therefore something that could constitute a private nuisance. The result of this hierarchy suggests that whenever we have something that doesn't fit with what we usually do in a private residential home, right? If it's not cooking, if it's not usual types of sounds, like playing music, not too loudly, not a brass band that's practicing every night, but just a regular type of use. All of these things are going to be more susceptible to claims in private nuisance. That includes things like a viewing platform that is a public service and it's free of charge in a museum. That includes commercial property, but that also includes things like the activities or uses of marginalized groups. As we know that those would not necessarily be deemed as part of the base characters from other studies about what is the things that reasonable people do. So we have this conceptualization of various land uses. This appears to explain why the visual interference cases were decided the way they did. They all seem to be abnormal. It's not things that people usually do. They either don't run a commercial enterprise in their home. They might not invite hundreds of thousands of visitors a year to look through their windows or their viewing platforms. They might not operate a sex store or jump nude on their trampoline, right? Those are all things that people don't usually do. We can see how they're more susceptible. So this brings us to the very last point that I'm making in the argument, and how can we have a rights-based account that is also considerate of the public interest? And this is something that at first glance would appear very strange for anybody familiar with Ernie's work, because it appears to be rejecting the idea that in anywhere we should have anything other than the two parties that are involved as playing a game. So how can we do that? So one way of doing that is through things or through an approach that is promoted by Aditi Bakchi, for example. Right? So she's saying that when we are able to identify instances where we have structural injustice, institutional injustice, we can either bring in one of these arguments. Either there is a moral responsibility for the plaintiff to refrain from bringing their claim because they will be perpetuating or recreating an injustice, which would be something that they need to avoid. That can happen under a certain set of circumstances. Or alternatively, we can think about ways in which we can use an existing doctrine to bring in or amend it so that we can have some kind of an account of that structural injustice and try and overcome it. So it doesn't mean that we need to necessarily. So I'll put it as an example, right? So when we think about reasonableness, there is a wide discretion that courts can use and decide what is reasonable and what is not. If we know there's some structural injustice, maybe we need to work with that doctrine a bit. Maybe we need to bring in some kind of doctrine in the remedy stage, for example, to avoid a situation where the courts is actually helping to perpetuate that form of injustice. So that's one type of argument. Another type of argument that I'm advancing elsewhere is that once you are able to articulate there is structural injustice, then you, depending on whatever rights-based approach you have, you might be able to use positive law to come in and amend that problem. That could happen through statute, that can happen through public law, that could theoretically and practically even happen through existing tort doctrines. Why? Because positive law can actually do something that doesn't necessarily follow that very specific structure that the moral norms require you. And that appears to be something that is more likely or reasonably needed if you try to achieve a situation of an ideal rightful condition, right? If you want to have an ideal rightful condition, you can't just relate to the bipolar relationships between parties. You need to account for the overall structure of that society as well. So I think we can articulate that in. So just to have a short recap of the entirety of the arguments. Right? So I argue that visual interference cases need to account for both looking in and looking at whatever is happening in land uses, that there is a right to look out of your own property, and you have a privilege of incidentally looking into other people's properties as long as their windows are open and viewable because they're in public view. You don't have a right to surveil other people because that will subordinate them to your whims. And it's a question about determining what counts as surveillance. I don't think that it's possible to argue in the context of Tate Modern, which is extremely busy, that we do have that form of surveillance through aggregated looks, because people on the ground level all have their blinds closed because they know that there are hundreds of thousands of people walking every day. And it doesn't appear to be just or correct to say that just because people live on the 20th floor, they should have different rights or be able to create duties to their neighbors just because they live further up and they don't live on the first or second or third floor. So that's one argument. The other argument is that we can see that there is an implicit hierarchy of land uses that judges use that creates a disadvantage to anybody who is not a privately residential property owner. And there is a way to think about how we can augment that through positive law and find a way to provide for the public interest in publicly used spaces that would not just be open and susceptible to private claims, to private nuisance claims. So I'm going to stop there, and I'm really looking forward to people's comments and questions.
Yeah, great. Thanks so much, Haim. So as usual, I'll take a queue of questions. We have some people in the room, but if you're online, yeah, feel free to use the raise hand function like Stephen did, or put a question in the chat. So Stephen, you can kick us off.
Thanks, Anthony, and thanks, Haim, for the presentation. I have just a very small question, just something that occurred to me as you were talking. So, and it's just maybe a line drawing exercise. So I have a right to look in, right? So in other words, if you don't have blinds up or whatever, I have a right to look in.
So I would call it a privilege.
Okay, privilege to look in. But you almost immediately then caveated that and said, well, of course, you couldn't use infrared looking in, right? So I couldn't use a kind of a heat sensor machine to go through your blinds, let's say, to see whether there were heat source, like people there. You know, I wouldn't see anything, but I'd get an outline enough of a heat blob to know whether somebody was there or not there. I guess I just don't know why the heat sensor or the infrared isn't just a better form of looking in, right? Like if I have the privilege to look in, why don't I have the privilege to sense the heat from within? So I wondered if you could say a little bit more about why you think there's a line between those things.
Yeah, thanks, Stephen. So I have an intuition that I'm going to try and advance. And I think that there's something that appears wrong when we think about doing certain things that are not just with our ordinary senses, when it comes to these things, right? So if we snap a picture of somebody, that's slightly different from incidentally looking at that somebody. And I think that if we use those infrared binoculars, or even if we use our smartphones and their telescopic lenses, that is slightly different from just using our ordinary capabilities and senses. So while we can say that it's going to be very difficult for us to put a limitation on our actual ordinary senses, so people shouldn't look, people don't have a privilege to look, people should find a way to look away. There needs to be something more to be said to explain why people should have a right to use things that require certain tools and things.
So I just interrupt you there.
Yeah.
I just, the point that immediately, of course, comes to my mind is that you and I are both looking at each other right now using corrective lenses.
Yeah. And a webcam.
So no, but I mean, leaving the webcam aside, right? Like, so in other words, you know, if you're truly falling back on unaided human capacity, then you're drawing distinctions between people who have really acute vision and people whose vision sort of sucks. And that doesn't seem right to me. Like, I mean, if I have the ability to wear corrective lenses, surely I'm allowed to look in using the corrective lenses, for example.
Yeah. So I completely agree with that. And I think you're flagging something that is a challenge that I'll have to think about and think about how I'm going to address it. But I think if I need to find a possible response to this, is that usually these types of arguments are building on a person who is this ideal person that we can be. And those would not be people like us that have glasses. Those would be people that can live without their glasses, right? So it would be the fully able people that are looked as the base according to which everything else is delineated. So we can think about people who have no eyesight. Would we say that they don't have a right to look out? I would say probably not. They just can't do it. But that's just because of the way that I think law tends to structure things. It tends to structure things based on this one ideal, and that one ideal tends to be this perfect human. And I can be more critical and say more things about who this person might be, but that's not the point of this particular paper. It's just a quick reference and a footnote. But that's why I think that it's fine for us to have corrective lenses, because we're edging closer towards that perfect human, but that perfect human doesn't have super eyesight, just as that person doesn't have terrible eyesight. So I think that might be the reason why. But we'll have to think more about this, because I think that's a really good challenge to kind of fully articulate the boundaries. Yeah, thanks.
Thanks. And Sashi, you have a couple of questions, and then there's a few in the room as well.
Hi, everyone, and hi, Haim. Good to hear you. I thought it was fascinating. So, three quick thoughts. First, about the privilege to look at someone in their own house. Were you thinking about potential ramifications in terms, for example, if you walk nude or masturbate or whatever, whether it might expose this approach might expose you to criminal responsibility for exhibitionism, because it seems to me that the risk is that, again, you're a bit challenge the distinction between the private and the public. Second question, I wonder about your motivation to tie the discussion to Eni's Weinreib's work, especially that in the area of nuisance, it seems that the reciprocity idea is much linked, with ideas of distributive justice, like Keating's fairness understanding. And then the third is just a quick thought. When you were talking, I was thinking about the male gaze, and I wonder whether this project you have any interest in engaging with that, and if so, where might it take you? Thank you.
Yeah, excellent. Thank you. Thank you, Safi. These are all great points. Let me start with what happens if somebody is doing something that it should be intimate and private, but you can accidentally see in through their window. So I'm not sufficiently familiar with criminal law about this, but I would assume that if somebody is at a park and is masturbating and somebody happens to see that person, then there won't be any kind of charges against that person. And the way that I think about it is that if people just leave their blinds open, so everybody can see, it doesn't matter that much, in my view at least, if they're in a public park or if they're in their bedroom. They've decided to be exceptionist and they've put themselves to public display. So I don't think that it would be a good idea. I don't think that it should attract criminal liability in that sense. And if it does, maybe there's a problem there as well, but maybe there's a problem with the way I think about things. Maybe I have a slightly different intuition. And I think that different people will draw the line on this slightly differently, right? So this is why all of these visual interference cases are a bit trickier than perhaps they appear to be, because they involve this kind of very fine line that different people will draw in different places. So that's about that point. About distributive justice and reciprocity. So in the paper itself, I touch on these in a couple of places. So distributive justice, I touch about more towards the end, but I think I will probably expand on that a bit more, especially when it comes to perhaps even remedies in the sense of where public policy can play a part. Reciprocity comes in quite a bit when it comes to the entire debate about, well, the way that Lord Leggett is framing the debate about whether there is a wrong because what the Tate is doing is so exceptional. It's not reciprocal in any way, shape, or form. I think that framing things in that particular way is slightly misleading. And I don't think that if everybody, for example, decided to turn their homes in a residential property into some kind of a tannery, if everybody had a tannery, I don't think that that necessarily would make it that it's absolutely fine that smoke and smell and noise transfer from one person to another in a way that you can't really live there anymore. It would change the way that that neighborhood is, and that will have to be accounted for, but I don't, it's the same as that I don't think that if everybody punched other people as a form of greeting, causing them severe harm, just a matter of empirical fact, that wouldn't make it okay. It would be a very strange reality to live in. So there's a bit about that. And about the male gaze, I have a very short reference to the fact that most of these examples are thought about with the reasonable use and the person using it as a man. But I'm not necessarily using the male gaze beyond that, even though most of the plaintiffs in all of these cases, and I'm trying to think of it, so some of them had a woman involved, but most of the plaintiffs in most of these cases were men. So I think there is something interesting to explore there as well in that relationship. So thank you. I will have to look at that. Thanks.
Thank you, Sophia Moreau, in the room. And I think we have the ability to turn the camera around for questions. And then so we'll try that. There we go.
Firstly, thank you so much. And I just want to apologize on behalf of those of us in the room who came in late. There was actually an announcement of your talk to faculty that went around that said the start time was 12:30. And so I'll show you later. So that's why we all walked in late and missed the first part. So many apologies.
Okay.
And hopefully the question is still relevant. So I guess I had a thought and a question. And the thought is partly is a kind of half question in relation to your response to Steve earlier. I was curious why you, in response to this, worried, well, what about infrared vision? What about glasses? You said, well, tort law works with a kind of ideal of the perfect person. And I was wondering why you didn't say, well, it works with an idea of the ordinary person or some sense of what we can expect, what the kind of vision we expect others to have. Because that seems to explain why we would think glasses are sort of normal or okay, but infrared vision is not. So I was curious about that. The second question has nothing to do with that, but has to do with the really fascinating remarks you made at the end of your talk about social justice and how that figures in. So I was just going to invite you to say a little more about that. This is obviously something a lot of us have been thinking about here, which is especially if you're more inclined to think about tort law as normally incorporating only considerations relevant to the two parties. But there are situations in which doing that looks like it would exacerbate the considerable background underlying injustice. What do we then do? And I was wondering in part whether you were moved by these sorts of considerations to think about some of the versions of tort theories that don't necessarily call themselves social justice tort theories, that are in a sense closer to formalist theories, but that adopt a more substantive conception of equality, right? So theories like Dagan and Dorfman's just relationships theory of tort law, which seems sort of similar to corrective justice theories in holding that the rules of tort law enable us to interact fairly with each other, but that seems to use quite self-consciously a very substantive conception of equality rather than a formal conception of equality. So I was wondering where you stood on that sort of question.
Yeah, great. Excellent. Good. So let me start with my response to Stephen and the perfect person rather than the ordinary person. So I think many times this is how kind of tort law is trying to, and private law generally, right? It's trying to say, reasonable person, ordinary person, et cetera, et cetera. I don't think that it actually does that, at least in the sense of when it comes to thinking who that person is in any kind of physical manifestation. I might be overly critical, I might be overly cynical, but I don't think that they're thinking about people with glasses. I don't think they think about people with any kind of minor disabilities. I think that they think about a person who has been created in his image, in a way. And they're perfect in that sense. So their mental capabilities might be ordinary, but their physical capabilities tend to be perfect. So that's why I said perfect. I might have misspoken, or maybe I've spoken too quickly, but I do tend to think that any type of disability or difference is ignored. And instead you have something that is not ordinary in the kind of empirical sense, where on average, people might be able to do this or do that. There is this kind of ideal and objectivity, and it tends to think about people in a better way, right? They're in the prime of their lives. They have these relationships, and these are kind of heterosexual relationships and kids and a house. So it's this kind of idealized version of people in a society that I don't think is just ordinary, or at least I don't think it's tied to what would be ordinary at this point in time. But again, I might have spoken a bit too strongly, so I might need to qualify that in rewriting this, because I have.
Talk about that for a sec.
Yeah,
that's really interesting. But I wonder, I think that does seem true actually about physical appearance and capacities and so on. Mm-hmm. There are lots of minor disabilities that are, in a sense, more common, but are just ignored. Mm-hmm. But I'm wondering if actually that's true maybe of mental capacities too. Mm. Yeah. That it's a kind of sanitized, whitewashed, more privileged version, which would mean, of course, that's a further place, right, where all these inequalities are hidden.
Yeah, I mean, it could be. I think that I will have to do a lot more work in actually going through case law to have a good, proper sense of that, because I think that tort law tends to treat mental capability as this kind of interesting thing. So when we think about psychiatric injuries, for example, that tends to be its own thing. When we think about children's capabilities, it tends to be its own thing, and how we differentiate between boys and girls. When we think about people with mental disabilities, that tends to be its own kind of thing. So I think that this is good. This is another paper, right? This is what we're going to need to do, right? We're going to need to try and figure out what's happening there, and if there is any kind of line that connects all of these, or are these just insular and secluded? But I'm not sure I have a very straightforward sense about that. But do you? No? Okay. Okay, excellent. So future research. We'll have to figure that out. Okay, great. So, and for your next point about other versions of tort law that might be more in line with social justice critiques. The reason why I haven't focused on them in the main bit, but just flagged a couple towards the end, was that I really want to try and analyze things through the prism that Lord Leggett is using and other cases are using, that is trying to kind of be very much rights-based focused, trying to follow Weinrubian accounts, because that is what he is trying to do, right? So if I bring in other versions, they would just reach different conclusions. We're not be really talking in the same kind of way. And I think that's, in a way, the relationship between Lord Leggett as the majority and the minority and dissenting views in Fearn, right? They're just not having the same conversations. One of them is rights-based and the other one is instrumental, focusing on policy, and you can see different results. The same goes for Victoria Park Racing, right? They are just having very different conversations and they're reaching different results. And I think that if we bring in another version, another vision for private law, I think that could be great. That could explain things. That could help clarify things. So definitely that is something that can be added in at the third part of this paper. But I think that for the first part of the paper, I will have to be very careful in how I implement that, because that might just kind of move us too far away from those arguments. And I'm trying to show why he's wrong on his earned terms, as opposed to why he's wrong on any other else, because that's just, everybody's doing that right now. He's wrong in every way. So hopefully that won't have a very lasting effect. And at some point we'll have the viewing gallery once more. So far, to no help. You can just enter the cafe and look through its glass windows at the people next door and their glass windows. So you just have, you're just a meter apart and a few glass windows, but no viewing platform at the time, which is unfortunate. But thank you. Yeah, this is really good.
Thanks, and Simon. And I think just to clarify, so I think it was the email that I sent at 12:30 earlier this week. So that's mea culpa. I did have a draft email clarifying the 12 o'clock start date, so that's my fault. But we're all here together now, and that's very nice. So Simon.
Yeah, so like Sophia, I had a question about looking in the window and all, and then a separate question. So I don't see why we need to appeal to a typical or an idealized body. I would have thought that 50 years worth of jurisprudence on the reasonable expectations of privacy, however ineptly you think the courts have dealt with it, at least furnishes the relevant principles, even if they've applied them poorly. If I were looking at you through Zoom, it would be because you had invited my gaze through Zoom, and there's a social and indeed in this case explicit norm that enables, solicits, facilitates technologically enhanced engagement, where no such invitation has been broadcast tacitly or explicitly in the case of the infrared light. So where I keep the windows open, there's a social norm that it's permissible for a person to look in. Where a person keeps the curtains closed, there's a social norm that I'm blocking my activities from the view of passersby. I'm not sure why we need to appeal to any sort of typified, idealized, legally configured body in order to discern that where there's implicit or explicit social norms and invitations that all understand on the same terms. It's just not clear to me why we need to start talking about special goggles and things like that. So I would have thought that, again, whether or not you're happy with what courts determine counts as reasonable expectation of privacy, they've been yammering away about it since at least the late 1960s. And that I would have thought supplies a perfectly satisfying answer. Obviously, there's more in perhaps other context to be said about tort laws, idealized, legally configured bodies, but I just don't see that we need to go there to solve this one. So I'd be curious to get your thoughts on that, but separately then, I may have, because I came at 12:30, I may have missed an aspect of the argument. I was wondering if I could invite you to say more about the queer lens or the queer pressure that's being brought to bear here. And in particular, what I wanted to ask about was the whims of the queer person. So obviously, where it's the case that my whims engage in subordinating another person, not a whole lot of work needs to be done in order to figure out what's wrong with my leveraging my whims and claiming that I've got a perfect right to whatever whims I care to indulge. But I take it that it's well known that judges, in a sort of conclusory way, like to use the term fetishistic as a way of rejecting certain preferred modes of property use, where it's doing this conclusory work. To say that it's being used in a conclusory way is to say, I as a judge just get to say that that's fetishistic, peculiar, strange, unique to you, unworthy of further attention. And by calling it fetishistic, I've done my analytical work, and no more needs to be said about why I'm rejecting your preferred use. So I would have thought, now I don't know, I mean, you can tell me if this engages with an aspect of your argument, but I would have thought that that's a very right place to go for the queer lens, because it's not obvious that all soi-disant fetishistic, whimsical uses of property are subordinating to others. It may be idiosyncratic to me, but it strikes me as bizarre and perhaps a good opportunity for a queer critique to inquire why it is that calling it idiosyncratic or whimsical or fetishistic without more counts as a good reason for giving a lower preference to that property use.
Yeah, perfect. Thanks so much, Simon. These are really good. Why do we need an ideal or reasonable body or physical term? So the reason why I think it's required is that if we just count on our basic social norms, then we will tend to think about what we would imagine to be our kind of ordinary scenarios, and they won't necessarily relate to those types of things that we would have, like in the Fearn case, where you have this kind of private space and public space happening side by side. And there, because you can see how the argument that Lord Liggett is giving, that we have hundreds of thousands of people gazing every day, all year round, that doesn't seem to be reciprocal. That doesn't seem to be ordinary. That doesn't appear to be part of the social norm that we expect as part of the give and take. So we can do that, but then it's not only that it's susceptible to lead to that kind of answer, because I mean, theoretically, it could be right. I just don't want it to be right for a variety of reasons. But I also don't think that it's right when the way that you frame things, the way he does, is through language of rights and obligations. So I think that goes a bit further to look away than just the ordinary social norms that can change, that can be very strange, that can be very ad hoc, that can actually go to different ways than what you would expect are in relation of rights and obligations between private individuals or any type of two-party scenario. And the reason why I then go on to the body is to try to explain the basics of visual interferences and how vision works and how existing in a space works. So I think you're right that social norms can do some of the job, but they can't explain the thing that the courts don't explain, the relationship of rights and obligations to a certain extent. So for example, we can say that in certain societies, even if your window is open, people shouldn't look in. And that is something that can't quite be explained in the sense of whether it's right or wrong to look in any kind of legal sense. Right, so I feel like I need to have that a bit more in, but I think you're absolutely right that there is an element of the fungibility based on social context that can play in as well. I see you have a follow-up.
Well,
Yeah,
so I follow that. So without disagreeing with anything that you've said, it strikes me that if the core worry is the instance where the social norm would permit a person to look in, and you think there are good reasons why they oughtn't to, whatever might be said in favor of that view, it's a social norms plus view rather than a social norms minus view. That is to say, the question of why I can't use infrared technology doesn't even get triggered by the example that you've just given.
Yeah.
It's not even on the table as a relevant complaint or as a relevant puzzle.
Yeah.
In other words, the puzzle now becomes, why aren't social norms doing enough? Not why don't we start there and use that as the floor? So as long as we're using it as the floor, it strikes me that you're making an argument as to what else is required in addition. But using it as the floor solves at least the Swati's own puzzle of infrared technology and every other example I can think of in which a person is using technologically enhanced methods of observing something that they couldn't observe otherwise. So at a minimum, it just strikes me that the problem of technological enhancement is not one, that's not a worry that the account that you've given invites.
Yeah. So I see that point, right? So I think that I need to have a slightly better articulation of the relationship between the social norms and rights and obligations in that sense. So I agree with you. This could be a very easy and simple answer if there's a way to articulate both of them and tie them perfectly together. But if I had to just stick with one line, and that is the right and obligations, which is the thing I said Lord Leggett doesn't do, and I think he should, and none of these cases do, and I think they should. Then having some kind of articulation that is either rights and obligations related or social norms related, that can do, I think, a bit more work. And I don't think that they undermine each other. I think you're just saying there's a much better, elegant way of saying this in a straightforward manner. So I agree, there is one. I think that for this argument to be kind of fully coherent, we need to have both. So I think that's good. And I think your other point about fetishism and them just saying, this is abnormal, this is horrendous, this is going to corrupt everybody, we don't need to justify more. Absolutely right. I completely agree with you. I think this comes in the queer theoretical analysis to an extent, right? This is basically what I'm saying. Right? So we're saying that everything is going to be at a disadvantage and at a risk because it is something that would be deemed as abnormal or horrible or terrible in that particular social context at that point in time. So it will be susceptible, and I agree. I don't think that is enough, right? We need to look at more things. I think that those things are not just the social norms. I think they're also the underlying rights and obligations, and also the more general impact on society, if we do want to try and strive to any kind of form of a more fully, richly just society. I just agree with you. And I think one of the problems with the case studies is that at least a couple of them are just interim injunctions, and they're very short and they don't say much in the sense of explaining their justifications. They're just, this is a knee-jerk reaction. Obviously, this is correct. Obviously, this is something that I've noticed in other areas as well. And like Anthony said, I had to respond with a book. So perhaps this is, I feel like, more project coming in, right? So maybe there should be a book as well. But I had to react to these particular things. But I think you have a very correct identification there, yeah.
Thanks, Simon. So back online for our next question, and Roderick.
Hello. Thank you for the paper. I suppose that the thing I kind of wanted to push back on was this wonderful sounding idea of you can't demand that anybody disappears from public view, and I can see why the awful cases that you discuss might trigger that sort of principle. What I wonder is whether one actually wants to have it as an absolute, as a limitless principle, because as soon as I put various kind of swastikas or T-shirts or whatever on the person who's next door visible, then that whether I really want to say that there's an absolute right that they and their property can remain on view. I'm less sure about as to whether I want it. So I agree with you that the cases you've actually got, horrible, wrongly decided, but whether one actually wants to say, well, there's no right to object to the images that are projected towards my property, where projection is just kind of metaphorical. And I suppose that where I kind of came from that, I thought, well, private nuisance got this locality rule, this sort of notion that somehow different localities can set, we're going to be an area where people can cause more, but you also have to tolerate more, or we're going to be a locality where you cause less, but equally you can tolerate less, that you can kind of complain at an earlier point. And clearly when those agreements are expressed, we have sort of rules that we kind of say, well, look, there's certain types of covenant that we just will not enforce, that those rules are so horrific from a social justice perspective that we're just not going to enforce those covenants. But actually, when the covenants are more aesthetic, everybody agrees that houses are going to be painted in the following 4 shades or the like, we're kind of happy to enforce them. And so it did strike me that I wasn't sure that nuisance law would be right to say, oh well, that, if people do live in an area where, like the posh part of Georgetown, where one might be able to say everybody's agreed that you don't have a full-size replica of a transformer outside your house. And you may know that this thing exists. I went and had a look at it. That you could kind of say, well, that's so contrary to the local rule that one can complain about it, that the effect it has on me just seeing this breach of the local rule, the massive transformer every morning, affects me in the same way as a buzzing noise or an unpleasant smell. So I guess I was just kind of pushing back on whether, if the rules were, in a sense, social justice neutral, that they were just sort of local aesthetic rules, whether you'd still be adamant that you just can't make somebody else's property choices disappear from view. Yeah.
Yeah. This is really interesting. So let me try and think about it. So let's say we're social justice neutral, but we're all about the locality. I think that your example of swastikas and transformers is interesting, because you haven't said that both of these things happen in the same kind of way, right? It sounded like swastikas were just somebody walking down the street, whereas transformer was an agreement of a community of house owners in a particular area. So my immediate reaction was, well, the transformer is something that's problematic. There is probably some kind of a contract or an agreement or some kind of a tenancy thing that's happening that's regulating that particular community. So maybe they have some kind of rights as against each other according to that particular agreement or contract between them, as opposed to the swastika example, where we can think about different societies having a different approaches to the limits of acceptable speech. So I think for the US, for example, it was very probably is going to fall under their constitutional protection of free speech, and that's not surprising considering who's in power right now and what they believe to be an appropriate wave. But putting that particular bit aside, I think that there are ways to say that type of visual interference or visual expression could be wrong and dealt with through other means. It could be public law means, or it could even be ways in which we augment private law, because we want to say that there is a limit to the type of speech that we accept. So we would either enact a statute that would allow people to bring claims against that, or that we might even want to change the way that we think tort law in particular should react to that. But I can see the challenge in the sense that on my account, ordinarily, without having that bit acknowledged, you wouldn't have a right as between two people to say that person should not exist in the public sphere. So people can actually walk down the street and have swastikas, and people won't have any kind of private right claims against one another, or people can put up swastikas inside their homes, so you can see them through the unobscured window. So if you look in, it'll be there, and people won't have an ability to bring a private claim in nuisance in that particular sense. And I think that triggers this kind of moral intuition senses, which that would be wrong. But I think that is just the flip image, saying that somebody has a brothel inside their home and you don't see it, but you know it's there and it's a problem. So we need to find a way to account for both. And I think that the way to account for both is through either public law or other ways of positive law that would set limits in order to make sure that you have this kind of interaction going. And I think that the society that we live in might have a particular moral view about sex work and a different moral view about neo-Nazis and the extent to which each is tolerated. And I think that could help, especially if we're bringing in the arguments that, for example, Simon gave or that Sophia gave. So I think that can come in. But I'm not sure if my argument about the transformers is as accurate, just because I don't know enough about those types of houses and communities, whether they actually operate a contract or whether it works in a slightly different way. I think you said that there's a covenant. So I'm assuming that there's something that's happening, at least that we can talk about, that is a form of a contract, but I'm not entirely sure. So I'll have to look into that and kind of flesh that out a bit more. Yeah. Thank you.
So maybe now's a good time for you to ask the question that I had. So Haim, I think that some of the things you say made me question or just wonder what you think about on a rights-based analysis, what privacy is actually doing in some of these cases. So when you talked about the privilege to look out and therefore look in, it's kind of rooted in people's proprietary interests, their ability to do whatever they want with their property, which includes looking out. In order to get at the question about whether privacy does something on the rights-based view, or like the Kantian view, basically, that's independent and freestanding, I wonder what you think of what's really the wrong of surveillance. Because you said it transforms into a kind of wrong, right?
Yeah.
So suppose that you're surveilling somebody from your own property, like your neighbor or something, with a telescope and looking in all the time, or like filming them all the time. And it's not that, so I guess you can take one view, which is that you're threatening the integrity of their body by making them live in fear that you're going to do something, or their property that you're going to actually trespass. But it seems to me like something that extra that's going on here is just that somebody has a right to privacy, which maybe is just the Canadian tort law side of me thinking in a way it's different from the UK tort law side, where there's that more robust protection. So I would have thought that you could tell a story like this that's very Kantian, it seems to me. And so there's some philosophical writing about what the value of privacy. So Thomas Nagel talks about, for example, in order to be able to present yourself to the world in a certain way, you need to have some space like behind closed doors to like cultivate what you're going to present yourself as. You need to be able to conceal yourself and like selectively expose yourself. It's part of your ability to pursue your own projects in life, is to have that ability. And so instead of saying something like surveillance, may interfere with someone's bodily integrity or property, it interferes with some other aspect of their autonomy. So the wrong here looks a bit more like defamation, where it's infringing on somebody's good name, and I can't remember exactly the Kantian term. Your right to be beyond reproach, right? Like, so it's separate from body and property. Does that kind of conception of privacy, is that doing any work in your account? Like, might it do some work in your account?
Yeah. So thank you. Yeah, this is very, very, very interesting. So the reason why I don't talk too much about privacy in this paper is because it's not something that is mentioned in the key cases of visual interference that I deal with. And I think that the UK doesn't have the same kind of view and torts regarding privacy as some other jurisdictions do, where it's a bit more straightforward and said that it's protected to various extents in some other pockets. But I think that privacy can definitely have a way of explaining some elements here, especially when you try to kind of demarcate the line between wrongful and unwrongful looking. So I'm not sure if I would necessarily use the account that you provide either for Thomas Nagel or about interference with bodily integrity. Instead, I would say something that's slightly different, right? I would say that when you surveil a person constantly, then there is a way in which that you cannot let them act as free people in the universe. Right? They can't just do whatever they want without interference, because there is this constant interaction, right? And I think that would require a certain element of knowledge that is happening to have that kind of particular actual effect. But once you do, you know that something wrong happened, right? So you can be completely unaware that somebody has surveilled you for a very long time, but the second you know, no, that was a wrong throughout. Why was that around throughout? Because I need to be able to act in a world without having this kind of constant gaze and surveillance. Because if that exists, it deters me from doing everything that I want to do and I should be able to do. I should be able to walk around as I please in my home, putting whatever music I have on without this kind of fear of judgment or without other people knowing, because if they do have that capability, then we are not completely free. And at the same time, I have to say that I haven't fully fleshed out an argument, so I'm not entirely sure that is a sufficiently good response to your question, because at some point you said, is this kind of like defamation? And I think that defamation is a bit more about how individuals are set and perceived in society, but also a little bit about the fact that by saying certain things, you can cause people to exclude them from society and from participation in society. So I say that there's a way in which privacy works similarly in a way that it doesn't, because the problem with privacy is that it happens even if you don't broadcast whatever you're saying to the rest of the world. And it's still a wrong. Yeah.
Yeah, well, I guess I think that the account that you're inclined to give about privacy and the sort of Nagelian, or I think Kantian account that I suggested are compatible, because I think you wanted to say fundamentally it's about independence. And I think that the account I'm giving too is independence, because if somebody's not giving you that space where you can conceal yourself, they're undermining your capacity to set and pursue ends that are independent from their gaze. I also think, and related to that last point, it's another benefit of thinking about this in privacy as a sui generis, independent entitlement, separate from property interests. Or so you can say something like, well, surveillance also like is a kind of harassment or something, and it interferes with my psychological, because I'm never sure when somebody's going to be looking at me. And it's kind of like. You need your mental capacities to set and pursue ends too. But I think privacy is something even separate from that. And the interesting thing about thinking about things that way, severing privacy from property, is that you can have privacy even if you don't have like what the courts deem as the optimal instance of property, like ownership. If you're a lessee, or maybe even if you're homeless and you don't have property, you can still have an interest in privacy when you're kind of trying to find, if you know, encampments, like taking down encampments might interfere with that sort of thing. So even I think it helps thinking about privacy as sui generis for the social justice project too.
Yeah. So I think that the reason why I don't want to say that privacy necessarily needs to have an element of hiding is because I think that to a certain extent, by surveilling somebody, even when they're in public, and they don't need to hide behind everything, right? There is a wrong there. And I think when you said harassment, that seemed to be echoing the right kind of way to perhaps view it, right? But if you have to have some kind of a way of concealing yourself in order to have privacy, I think you're missing some elements of what privacy could encompass and what kind of wrongs could happen. I really think that if people just stare at you constantly, follow you, take your picture, maybe even draw your liking, even if you're in a public space, there's something that's done there that could potentially be a wrong, regardless of whether they can hide behind a bush or a wall. But I'm not sure if you would agree with that.
Yep. Okay. Questions? So far, and then Simon.
Okay. For an addendum to, so it strikes me on the account you just given, the wrong occurs independently of whether the person's aware that they're being surveilled.
Yeah.
And that seems like a non-trivial aspect of it. That is, so yes, if you reveal it to me 5 years in, I feel that, I've suffered 5 years of it. But indeed, even if you don't reveal it to me, it strikes me that the arguments that you've given are arguments for saying that I've been wrongfully subjected to a person's gaze, even if it didn't have the psychological consequence of my, structuring my behavior differently or experiencing my life differently because of my awareness of it.
Yeah, just like trespass to person. If you're asleep and somebody touches your hair and you don't know, that was still a trespass to person. And I think that's absolutely fine. Yeah.
I'm not actually sure, but that if you want to explain the wrong in part by virtue of its interference with someone's freedom, then that seems to happen by means of their psychology.
I agree. It's a very good
So
question.
I don't think it's not clear to me that you think that if you survey me and I'm unaware of it, have you interfered with my freedom? No, we need to explain why that's problematic some other way. So actually, this leads into what I was going to say. I'm actually skeptical of the idea that merely being looked at is an interference with your freedom. I feel like we have to explain it some other way. If I'm constantly surveyed, but those people who are surveying me do not have the power to interfere with me in any way, influence public opinion about me, restrict my options, has my freedom been affected? I want to say no. So in the mere fact of the gaze doesn't seem to be, it's what takes away my freedom. It seems to be the probable consequences of various people gazing at me and what they will then do as a result of what they have seen when they gaze at me.
So do you think that it's necessarily what the other people might do? Because that kind of leads us towards more of a kind of the defamation picture? Or is it something that now that you know that you're being observed constantly, you're going to do different things?
Possibly, but there's a real question then, depending on how you understand freedom, as to whether even that constitutes a restriction of my freedom, or just, as it were, that just makes it more difficult for me to use the freedom that I have. It imposes various sorts of costs on the activities that I'm still free to engage in.
Yeah,
these are really interesting questions.
Yeah. No, so that's really interesting. I think that if we do end up going with that particular direction, and even when we say that surveillance doesn't necessarily infringe freedom in any way, shape, or form, then we can see another way about how these visual interference cases are wrongly decided, right? So stare. You're free to stare. I mean, windows are wide open. It doesn't interfere with anybody's freedom. There was nothing wrong there. So I think it helps that end of the argument, but I think it brings in something else, right? Because then there needs to be some kind of explanation about, is there actually ever a limit when it comes to visual interferences, or are all these things just absolutely fine? So there's something, there's something additional to think about here. Yeah, thank you. Yeah.
I think as we're nearing 1:30, then our usual end time, we can finish up there, having seen no other questions online. So thank you very much, Haim. It seems like as a result of the discussion, there's a lot more interesting discussions to be had.
Yeah,
it makes it a success. So thanks very much for joining.
Perfect. Thank you so much.
Thanks everybody online for tuning in.
Perfect. Thank you.
So